Hey guys, it's me. I'm back. I'm back. I'm back. I'm back. Hold on, I've got to turn on this light here. Ooh, put a light on the subject. Me and my lights, boy. My light's not really good today. Hey guys. Hey, hello, hello, hello. All right, I'm gonna give you some quickie update in regarding the YSL case. I'm sorry, regarding the YSL case. You know what? Let me go get the footage. I forgot I left it downstairs. Just hold on a second, y'all. Say hello to each other while I go get the footage. Hold on, let me play some waiting music. Hold on. Let's see. Let me play some waiting music. All right, guys, I apologize for the time it has taken me to get the video up. I just want to bring the video up for you guys for the footage. In the beginning, there's no sound, okay? So don't be alarmed. It's not me. There's no sound, okay? So since people complain about me talking through the video, I'm just gonna let y'all see these footage. This footage is not long, and then I'll go ahead and give you the motions. Sounds good. He says definitely the waiting music. Hey, everybody in the chat. Let me say hello to folks. Hey, Gigi. Hey, K baby. Hey, Anna Kenya. Hello, One Cool P. Hello, Sharon. Hello, Cynthia. Hey, Sierra. Hey, Nosy Rosie. Hey, Felicia Fee. Hey, Bree. Hey, Coco. Hello, sexy grandmother. Hey, VK. Hey, Ashley. Hey, Trissy. Hey, Diego. Diego, what's up? What's going on, Diego? You always slip up in here. What's going on? Where you? You at work? Diego, you at work? You at work? Hey, Lee Tenberg. Look at the volume now, y'all.
All right, Mr. Brown and Ms. Hilton, good afternoon. Mr. Randolph and Ms. Von Kels, good afternoon.
I'm going to be quiet today.
Ms. Von Kels, any administrative announcements, madam?
Yes, Your Honor. The second juror, juror 951, has a language barrier as we are waiting on Mr. Levitt.
All right, well, once we see Mr. Lyles, we can take 951 out of order, okay? Anything else? Okay, all right. Let's start off, Mr. Randolph, with 945, please. Yeah. Thank you, sir. Juror 945, good afternoon.
Good afternoon.
Sir, do me a favor and speak directly in the microphone so we can all hear you, okay?
Good afternoon.
Okay, wonderful. Sir, you identified for hardship, we identified you, and that basis is based upon transportation, is that correct?
Yes.
All right, can you tell me a little bit about it so I can grade or evaluate it?
I do not currently own or possess a vehicle to regularly make my way down here. I live an hour drive away from here.
Where do you live, sir, in our county? Not your street address, but can you give me the area of town you live in, like Roswell, Buckhead, Alpharetta, Johns Creek?
Alpharetta, near the border of Milton.
All right, how'd you get here today?
I got a ride from family.
In terms of your employment, we have a little bit of information about you. It's self-provided. So you're an analytic developer and you work for Integrated Analytic Solutions. Is that correct?
Yes, sir.
How long have you been with them?
3 years now.
How do you get to work for them? You work at home? You go to a hard site? Tell me how you get there.
I work at home.
So family, how'd you get here the first day you were called for jury service?
I got a ride from family.
So you own no car?
No car.
What do you do when you need to go someplace else, either socially or for work or for anything else?
I rent a car, or if it's available, I borrow a family car.
How close is the MARTA to you?
Roughly a 30-minute drive.
30-minute drive, y'all.
Sir, I don't know if transportation ordinarily would be a reason to exclude you for hardship. The law only gives me a limited number of bases for us to go ahead and provide you relief from hardship. People from all over our county, north, south, east, and west, tend to make it to the courthouse.
I understand.
Would it be something that you just have to figure out with your family's assistance? You live at home with your parents?
I do, but I would have to purchase a car to make it down here regularly.
Let's talk a little bit about your employment situation. And there's a reason for it. How long have you been with Integrated? You said you've been with Integrated 3 years, right?
Yes, sir.
You salaried or hourly?
Hourly?
How much do you make an hour?
I believe it's $28 an hour.
$28, okay. How much did you make last year? Just
I believe
guessing.
76,000.
Okay. And let me ask you some other questions ordinarily be none of my business. Do you happen to know what your company's juror policy is?
I have a copy of it with me.
Can I see it?
Yes, sir.
All right. If you wouldn't mind handing that to Deputy Ingram for me, please. Thank you, sir.
It's the last section.
Okay, juror 945. I'm in possession of the policy, but it looks like you need to tell them, your employer, if you get selected for jury service so they can cover your job or duties. Is that correct?
Yes, sir.
Do you have any more of this policy or did you talk with HR about how much they would cover?
I believe that's the entire policy.
So will they pay you no matter how long you're here for?
I do not know.
Can you do me a favor and if I were to release you to go outside and call your HR at Integrated and kind of just say, hey, is there anything further to 6.10 jury duty and see whether or not they are in fact going to pay, cover if you were selected for jury duty of up to 6 months or greater, would they pay you? Because it doesn't, this is kind of just, it stops. It says, employee must bring in the jury duty notice as soon as it's received so that appropriate arrangements can be made to cover his or her duties. Or employees are required to call in and report to work for those days or parts of those days where their presence in court is not required. It doesn't say anything about length, or it doesn't kind of just say if there's anything further to 610 in this particular section, okay?
Okay, I can contact them.
Okay, if you'll just step outside and let Mr. Randolph at the door know when you're back, I'll include this as a next court exhibit in order once our juror completes his inquiry. You can come back, okay?
Yes, sir.
All right, in the meantime, Mr. Randolph, 975, please.
Yes, John.
All right, juror 975, good afternoon, madam.
Good afternoon.
Once you get settled, pull that chair up as close as you can to the microphone, speak directly into it so we can all hear you, okay?
Okay, thank you.
All right, wonderful. Madam, you either identified for hardship or we identified you. And three bases I have financial, transportation, and medical. Is that correct?
That's correct.
All right, madam, do you have any documentation or an affidavit from your doctor?
No, I do not. I just have diabetes and a lot of metal in my body that makes it difficult to sit.
You said what type of diabetic are you, madam? If I can
Type
ask?
2.
So do you take medication?
Yes, I do. I take metformin and Farxiga.
Okay. And what was the last thing you said? You said you had diabetes, and did I hear you say you have a lot of metal in your body?
Correct. I've had both my right knee and left knee completely replaced.
Yeah, total knee replacements, both right and left.
And I had 2 metal rods in my back, metal spacers, and a metal cage around my spinal cord from L1 down to S1.
From
A car accident.
car accident, okay. So I take it that, does that make it difficult for you to sit or tell me how that affects you?
I can't sit for very long periods of time. I cannot stand for long periods of time. I cannot walk for long distances. I get a lot of pain. I stay in a lot of pain.
Do you take any narcotics at this point in time or?
No, I refuse to take those kinds of things.
Okay, any type of over-the-counter stuff like Aleve or?
I take Tylenol.
Tylenol, okay. If you were to grade your pain that you're in right now, 0 being none, 10 being the worst that you probably had, where do you fall on the continuum today?
I'm probably in 9.5.
Okay. Does your pain affect your ability to pay attention?
Yes.
All right. So if you were called in for trial on this particular case, do you believe that your pain and current medical conditions would prevent you from listening to the testimony presented and giving it your undivided attention?
Correct.
Would that affect your ability to be fair and impartial to the state as well as to each individual defendant?
Yes.
All right, counsel, is there any further examination I need to make of juror 975? Anything on behalf of any individual defendant? All right, may I excuse juror 975 for hardship, counsel? All right, madam, I'm going to go ahead and excuse you. I'll wish you all the best, okay?
Okay, thank you.
Thank you. Juror 1000, Mr. Randolph.
Thank you.
Juror 1000, good afternoon, madam.
Good afternoon.
Madam, do me a favor. Once you get situated, pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you, okay?
Okay.
All right, madam, you identified for hardship, we identified you, and that basis for hardship was travel. Is that correct?
Yes, sir.
Okay, where are we headed to and what dates are we traveling?
Friday, June 2nd, Monday, June 5th, and Tuesday, June 6th. We were headed to Charleston, South Carolina. I'm the troop leader for my daughter's Girl Scout troop.
Okay, so that's 2 to 5 June and then 6 June to when?
Friday, June 2nd, Monday, June 5th, and Tuesday, June 6th.
Okay, any other dates of travel?
Yes, sir. Monday, June 12th, and Tuesday, June 13th.
Okay,
That is a vacation,
okay,
North Carolina.
what else?
Wednesday, July 19th, Thursday, July 20th, and Friday, July 21st. There is a youth group trip to Maryville, Tennessee,
Okay,
which I'm volunteering at. And then Thursday, September 7th, and Friday, September 8th, Operation One Voice has a Warrior Weekend, which I volunteer at.
all right, now just hang tight 1 second.
Thank you.
Madam, the trip that you're taking 7, 8 September, where is that one to again?
It's in Sandestin, Florida, sir. It is for an organization called Operation One Voice.
When did you book that trip?
It is an annual trip, sir. We've been doing it for about 15 years. My husband is on the board.
What kind of organization is it? I'm sorry.
It supports special operations soldiers. It's a family weekend for them at a resort. And my role in that is to help with childcare and just with the event.
Madam, can you show me some type of documentation or something showing it's an annual event or your participation thereof?
Yes.
You have some document, something you can show me on your phone? That'd be wonderful.
I have, thank you. I don't have anything that actually says that a reservation, the organization does a reservation, and it's not published on social media or on their website for security reasons.
How long have you been involved in this particular organization?
About 15 years or so.
Is your spouse prior military?
No, he's not, sir.
How'd you get involved with it?
My husband does fundraising for a living, and he was asked by the original organizer of Operation One Voice to help with fundraising, and that morphed into him being on the board of this.
Okay, baby, you funny. Okay, baby, you funny. Oh my God.
All right, counsels, it appears that juror 1000's involvement in Operation One Voice, it is a 501(c) company. She has some documentation on it. Just a quick web search indicates it's been around since 2003, and they do, in fact, have this particular annual event. Is there any further examination I need to make of Juror 1000? Anything further on behalf of any individual defendant? May I excuse Juror 1000 for hardship? All right, Mallory, I'm going to excuse you for hardship and wish you the best, okay?
Thank you.
All right, thank you. Yes, thank you. You can keep it. Okay, Christine, why don't you pull that first thing off and give her the rest of it back? 1049, Mr. Randolph.
Yes, Your Honor.
Thank you. juror 1049, good afternoon, madam.
Yes, you.
Madam, do me a favor and speak directly into the microphone so we can all hear you, if you wouldn't mind.
Okay.
Much better. Okay, all right. Madam, you either identified for hardship or we identified you and predicate on two things, or related to one. You're moving and relocating, is that correct?
That's correct.
Did you move already?
No,
When are you supposed to be moving?
July 5th,
July 5th, and where are you moving to?
Houston, Texas.
Is it to take another job, you or your beloved?
To take another job.
All right, do you have some type of documentation or showing that you've accepted a position or that you are in fact moving, madam?
I could provide my contract at MD Anderson.
If you could just show that to me, that would be sufficient.
Okay. Is it okay if I pull it up on my computer?
Yes, you can.
I apologize. I had brought different documentation for my particular hardship, so.
Do you have anything on your phone, an email, something like that? I just need to see something.
Yeah. And I have this particular letter. Yes. Sorry. Different, maybe that may be sufficient.
Thank you, sir. Doesn't really help me. I'll give that back to you.
Sorry, here's my contract if that
All
is helpful.
Yes, let's see that. When's your start date at MD Anderson?
August 1st.
Okay.
Scroll down.
Thank you, sir. Okay, councils, I am looking at juror 1049's offer letter from MD Anderson, which she accepted on March the 26th of this year, showing that she will be beginning employment from 08/01/23 to a period of at least 07/07/31/24. I'm going to hand you back your computer now. Council's, any further examination is required for juror 1049? Anything on behalf of any individual defendant? May I excuse juror 1049 for hardship or relocation for residency? Okay, madam, I'm gonna go ahead and excuse you. Wish you the best, okay?
Thank you.
Mr. Randolph, has, Mr. Lawrence, come yet?
Yes, Your Honor, you're right.
Okay, if, he and juror 951 would enter, please.
Yes, Your Honor.
Thank you. Mr. Lawrence, can I get you to raise your right hand for me, please? Do you solemnly swear or affirm that you shall well and truly interpret those responses from English to Spanish and Spanish to English for your best of your knowledge and belief, sir?
I do, Judge.
And you are a state certified Spanish interpreter, is that correct?
I am, Judge.
And you're employed with Fulton County, is that right?
I am, Judge.
Okay, you can put your hand down, sir. All right. Mr. Lawrence, I understand that juror 951 is a Spanish speaker, so can you welcome him and just ask him if his juror number is in fact 951.
El juez entiende que usted no habla inglés, que usted habla español. El juez entiende que usted fue designado como jurado bajo el número 951. ¿Es su número correcto? ¿Y es correcto que no habla inglés?
Correcto.
Correct.
Okay, and he's identified for hardship, that he has he's self-employed and as Spanish is his first language.
El juez entiende que usted ha indicado que habla su idioma principal español y que se encuentra empleado por su propia cuenta. ¿Correcto?
Correcto.
Correct.
Okay, the first day that he came for jury selection, was he able to understand the juror video?
Cuando vino usted la primera vez para ser parte de este jurado, pusieron un video. ¿Usted entendió lo que el video mostró y decía?
No.
No.
What didn't he understand about it?
¿Qué entendió del video o no entendió?
Solo las imágenes.
Only the images.
Okay, all right. Sir, are you a U.S. citizen?
¿Es ciudadano norteamericano usted? Yes.
When did you become a U.S. citizen?
¿Cuándo se hizo ciudadano?
No me acuerdo muy bien, pero como hace 11 años.
I don't remember very well, but about 11 years ago.
Okay. Did you take the citizenship exam in English or Spanish?
¿El examen de ciudadano que le dan, lo hizo en inglés o en español?
En inglés.
En English.
And what do you do for a living? You're self-employed?
He took a test in
¿Cómo
English.
usted que trabaja por su cuenta? ¿Qué hace exactamente?
Construcción.
Construction.
You speak English to do your construction duties or Spanish?
En sus obligaciones de trabajo en la construcción, ¿habla más inglés o español?
Español.
Spanish.
Did you complete high school here in the United States?
¿Usted terminó su high school en los Estados Unidos o dónde?
No, en mi país.
No, in my country.
Okay, where are you from?
¿De qué país es usted?
Venezuela.
Venezuela.
Anything further, Mr. Brown? Anything further on behalf of any individual defendant?
No, Your Honor.
May I excuse your 951 for hardship? All right, I'm gonna excuse juror 951, Mr. Lawrence, for hardship. He can do and tell him that he's being excused for hardship.
Entonces el juez está excusándote de prestar este servicio por estas limitaciones.
Muchas gracias.
Thank you very much, he says.
Yes, yes,
945 has information for you.
okay, well, as soon as 951 clears, we can go ahead and have 954 resume the witness stand. Thank you.
Thank you.
Okay, juror 945, welcome back.
Thank you.
Speak in the microphone for me.
Thank you.
Okay, what did you find out from your employer, Integrated Analytical Solutions?
They don't yet have a policy regarding juror service that's that long.
I'm sorry, one more time.
They do not yet have a policy regarding juror service that's that
Will they
long.
pay you if you're selected?
I do not know yet.
You didn't
I'm
ask that
awaiting-
question?
You didn't
I
ask that
would ask
question?
that question. They don't have that they've never had to deal with a case this long.
Okay, all right.
I'm
Sure.
awaiting their decision.
At this point, I think you're gonna have to probably come back for further examination at some point. It's probably gonna be at least probably about 8 weeks down the road. You can ask your employer and see if you can get granularity as to whether or not they will in fact pay. I think you need to know that as well as they need to tell you. So, but you want to make sure that their policy is broad enough, and you want to cover yourself just to make sure will they pay for your service if you're here 6 months or greater. Okay.
Yes, Your Honor.
All right. The other thing, in terms of your transportation, you'll have to make that work. I'll tell you, of course, you'll be given a schedule when you need to kind of come down here, but let's, and you can let us know what you worked out when you come back, the next, in about 8 weeks or so. And we'll just see how that plays out. Okay.
Understood.
All right. Three things. First one is, you remember the juror letter that you received that has your unique juror number on it? That was before you left here that first day, and the after hours number you're supposed to call?
Yes, sir.
Okay. It's going to be a minute before we reach back out to you. Probably, like I said, probably 6-8 weeks or thereabouts. So you don't need to start calling it immediately, but we'll also call you as well in conjunction with putting that information on the after hours line. So just check that from time to time just to make sure. Second thing is, you remember the ad nauseum admonitions I gave you about acceptable behavior?
Yes.
You're still subject to those. And then the last thing is, thank you for your patience that you've given us thus far and will continue to give us. And with that, sir, we'll talk with you in a little bit, okay?
Okay.
All right. Take care.
You too.
Yes. Okay. Okay, I believe that's all of the hardships that we have. Let me just go through a little administrative at this point in time. I'm going to mark this correspondence I received from Mr. Steele and his law firm in regards to the 2 dates that he is going to be arguing before the Supreme Court of Georgia on the 20th of April and the 18th of May. I'll include that as the next court exhibits in order. We've already talked about his excuse me with the permission of Mr. Williams already. Okay, anybody else have any other administrative inquiry of the court at this point in time? Tomorrow, the 12th of April, we are starting hardships at 1 o'clock. And we will, do we know how many hardships we have tomorrow, Ms. Von Kelch? So we shouldn't be here very long. And I feel pretty confident that with Ms. Fagan's assistance, we can get through those 3. Okay, so, all right, but other than that, anybody else have anything else? Mr. Garner, can I ask you a question? When is Mr. Harvey rejoining us? Okay, I have some other of my judicial colleagues that would like to make a specific inquiry I want to talk to them about. So just need to see him more about that. Okay. All right. Anybody else?
1 o'clock.
1 o'clock tomorrow. Yes, sir. All right. Anybody else? All right. Unless there's anything else, I will see you all tomorrow at 1 o'clock. Okay. All right. We're in recess.
Thank you, sir.
What is he looking at? Yeah, what is he looking at? Sierra said his imaginary friends. All right, that cameraman sucked. That's why I didn't put too much of my my what's the name on, my logo on. If you notice in the beginning, since he gave us a little short clipping, I didn't put my what's the name on because the camera guy sucked. All right, so let's go ahead on and give you guys some of the updates in regard to the that was quick. You see how quick court was over with? It's like boom, boom, out. So that's why I was done so quickly. All right, let's all right, let me go ahead and pull these up. All right, so we're gonna start off with some of the old motions that were submitted. He didn't get his psych evaluation yet. No, he has not gotten it yet. So he's supposed to be getting that done. Oh, I gotta show you too. Okay, let's start with Mr. Blaylock, the one that you just saw a few minutes ago. Let's start with his paperwork. His the motion that his attorney put in. The state responded to his motion for to exclude prior conviction, and I'm gonna read to you what the government says in regards to his motion. They're in opposition for that. This is new. What are you talking about? It's old to the court, but it's new to y'all because y'all ain't see it. Crushy, look, what I tell you about here. You starting with me today, huh? Crushy, don't start with me today. You've been good, Crushy. You've been good. Don't start, Crushy. Don't start with me today. Did you hear me, Crushy? Don't start with me today. Talk about nothing old, new stuff. Don't start with me. All right. Here we go. This is dated April 5th. You're not always good. You be stuck. Where my other buddy at? Where's the other buddy? Crushy, you, the other one that used to come in here and start in trouble. All right, here we go. It says state respond to, okay, let's do Georgia, state of Georgia versus Damon Blaylock. And you should know the case number. Case number 22SC 183572. State's response in opposition to Damon Blaylock motion to exclude prior conviction on direct appeal. It says the state of Georgia, by and through the undersigned district attorney Fannie T. Willis, hereby responds in opposition to defendant Damon Blaylock March 20th, 2023 motion in limine to exclude any reference of the non-final conviction of Mr. Blaylock in case number 19SC168236 as same is currently on direct appeal. In support of this response, the state shows the following. Defendant Damon Blaylock is charged in this indictment with conspiracy to violate the RICO Act OCGA 16-14-4C. On October 1st, 2021, the following trial before a Fulton County jury in case number 19SC168236, Blaylock was convicted of murder. OCGA 16-5-1, 2 counts of aggravated assault with a deadly weapon. OCGA 16-5-21, criminal damage of property in the first degree. OCGA 16-7-22, and possession of a firearm during commission of a felony. OCGA 16-11-106. On December 9th, 2022, pursuant to OCGA 24-6-609, the state filed notice of its intent to impeach Blaylock in the trial at the instant matter with evidence of his prior felony conviction from case number 19SC168236. Blaylock's conviction on case number 19 SC 168236 is currently on appeal, pending a motion for a new trial. Blaylock asserts that because this conviction is on appeal, any mention of reference to this conviction of Mr. Blaylock, in this case, 19 SC 168236, must be excluded from evidence in this case. Defendant's motion at unnumbered P3, paragraph 3, emphasis omitted. Blaylock is flatly mistaken in this assertion. OCGA 24-6-609 explicitly provides that the pendency of an appeal shall not render evidence of conviction inadmissible. Emphasis applied. Blaylock also contends that in that introduction of his prior felony conviction in the instance matter is improper because it would effectively deny Mr. Blaylock his constitutional right to testify on his own behalf. Defendant motion unnumbered paragraph 2, P2, paragraph 5. Blaylock cites no authority in support of this meritless contention. Indeed, his argument ignores controlling precedents from Superior Court of Georgia, specifically indicating otherwise. The constitutional right to testify does not carry with a right to prohibit impeachment of prior conviction. Childs versus State. Okay, it gives you the case number. Why do people keep texting me? Okay, finally, Blaylock argues that introduction of prior, okay, we already did that one, sorry. No, we did that. No, we didn't. Argues the introduction of his prior felony conviction for impeachment purposes in the instance matter would somehow violate his statutory double jeopardy provision confided in OCGA 16-1A. Defendant's motion of unnumbered paragraph PP-2-3, 6, paragraph 6. Blaylock's argument is unveiling. There's no double jeopardy here. The double jeopardy clause of the Fifth Amendment prohibits that any person be subjected to the same offense to be twice put in jeopardy of his life or limb. Constitutional Amendment 5, Article 1, Section 1, Paragraph XVVV. I don't remember my Roman numerals. Sorry, guys. I think that's 23, right? 28. That's 28 or 18. That's 18. Because 1X is 10 and then 5, yes, 18. Paragraph 18 of the Georgia Constitution contain essentially the same language. Double jeopardy renders unconstitutional a second prosecution for the same offense after conviction. Albernaz versus United States. OCGA 16-1-7A provides that when the same conduct of an accused may establish the omission of more than one crime, the accused may be prosecuted for each crime. Emphasis applied. However, an accused may not be convicted of more than one crime based on the same conduct if one crime is included in the other. ID in determining whether one crime is included in another under OCGA 16-1-7A. This honorable court is bound by Drickard versus Walker, and then a case number, which adopt the double jeopardy test used by Blockberg versus United States, and there's a case number on that. Under Blockberg, the applicable rule is that where the same act or transaction constitute a violation of two district statutory provision. The test to apply to determine whether there are two offenses, there are two offenses or only one, is whether each provision requires proof of a fact which the other does not. The Blockberger-Drickard test focus on the elements of the offense charge, i.e. the proof required, not the evidence produced at trial. And then the case number here, Jones versus State, United States versus Phyllis, and Brown versus Ohio. A single act may be an offense against two statutes if each statute requires proof of an additional fact which others does not. An acquittal or conviction under either statute does not exempt the defendant from prosecution and punishment under the other. Then you see a case here, punctuation omitted. Okay, application of the Blockberger-Drickard test here makes clear that there is no double jeopardy. Each of the overt act of Blaylock purportedly challenges contains different elements from the RICO conspiracy violation. For example, while Act 79 murder is an act of racketeering activity under RICO, it is not an essential element of a RICO conspiracy violation, which can be committed without any act or racketeering activity occurring and can be based upon racketeering activity other than murder. The same analysis applied to two other overt acts Blaylock purported to challenge: Act 80, aggravated assault with a deadly weapon, victim Bernard Mitchell Jr., and Act 81, aggravated assault with a deadly weapon, victim Rodney Oten. Notably, Blaylock argues utterly fails to address the staggering amount of authority holding that a RICO conspiracy conviction may be based upon the act which the defendant has previously been convicted. Rogers versus State, United States versus Gonzalez, introduction of RICO conspiracy, prosecution of conduct for which defendant has previously been convicted does not violate double jeopardy. United States versus Link. Introduction of prior conviction prove essential element of the RICO conspiracy does not violate double jeopardy. United States versus Caporal. Use in RICO conspiracy prosecution of overt act for which defendant was previously prosecuted and which he pled guilty does not violate double jeopardy. United States versus Bolden. Use in RICO conspiracy prosecution of a prior conviction from three separate cases does not violate double jeopardy. United States versus Watchmaker. Use of RICO conspiracy prosecution of evidence that the defendant operated prostitution ring for which he had previously been convicted does not violate double jeopardy. For this reason, the state respectfully requests that this honorable court deny Blaylock's March 2023 motion to exclude evidence of Blaylock's prior felony conviction in Fulton County Superior Court, case number 19 SC 168237. Okay. And that's it on that. All right. We got that one. Okay, let's do the next one. That was Blaylock's motion to exclude his prior conviction. Now we're going to go into Farley's. This was filed today. This is Farley's. All right, let's do. Okay, Farley's. All right. In Superior Court, Fulton County, State of Georgia versus State of Georgia versus Miles Farley, and then the case number is 22 SC 183572. Defendant is Miles Farley. A state motion to dismiss Miles Farley's demand for speedy trial. The state of Georgia, by and through the undersigned District Attorney Fannie T. Willis, hereby moves this honorable court to dismiss defendant Miles Farley's November 29, 2022, demand for speedy trial by juror. In support of this motion, the state shows the following. 1. The above style case was indicted in August 5th, 2022 during the July term for court for this jurisdiction, OCGA 15-6-3- parentheses 3, close parenthesis. Defendant Miles Farley is charged with indictment with inter alia murder, which is capital offense for the purpose of OCGA 17-7-171. Walker versus State. OCGA 17-7171A provides that any person included of a capital offense may enter a demand for a speedy trial at the term of the court in which the indictment is found, or at the next succeeding regular term thereafter. A speedy trial demand is untimely unless made within this time frame. Johnson versus State. Okay, let's go down. Number 4, OCGA 17-171A further provides that a demand for trial filed pursuant to this code section shall be filed as a separate, distinct, and individual document and shall not be part of any other pleading or document. Number 5, lastly, OCGA 17-7-171A provides that such demand shall reference this code section within the pleading. Number 6, Farley statutory speedy trial demand for file neither during the term of the court of court at which the indictment was found, the July 2022 terms of court, nor during the next subsequent terms thereafter, the September 2022 term of court. OCGA 15-6-3, because it was filed during the November 2022 term, the court Farley's November 22 statutory demand is untimely, invalid, and subject of dismissal. Johnson 300 GA, and it's a case number. Statutory speedy demand properly dismissed where the defendant did not file demand during terms of court at which the indictment was found and during next subsequent terms thereafter. Number 8, Farley untimely November 29th of 2022 statutory speedy trial demand is not redeemed by virtue of former Fulton County Superior Court Chief Christopher S. Brasher, April 28, granting relief from statutory speedy trial requirement pursuant to OCGA 38-3-62B, Exhibit A. This order granted relief from statutory speedy trial requirement applicable in this case from May 2nd, 2022 to January 1st, 2023. ID at 1. However, the order specifically grant relief from the timeline within which a trial to try a case for which a demand for speedy trial has been filed to OCGA 17-7-170 and 17-7-171 ID emphasis apply. The April 28, 2022 order did not relieve Farley of his duty to timely file his statutory speedy trial demand. Farley untimely November 29, 2020 statutory speedy trial demand has not been allowed by special permission of this Honorable Court, OCGA 17-7-171. And by special permission of the court, the defendant may at any subsequent term thereafter demand a speedy trial. Farley's failure to obtain such special permission is fatal to his statutory claim. Abbott versus State. And it gives emphasis supply. As the Supreme Court of Georgia explained in Abbott, the statute is absolute clear as to when an accused may of rights make a demand for a trial thereunder. I don't understand what she just wrote. Okay, I don't understand what she wrote. At the term of which the indictment is found, or at the next succeeding regular court term after that time, such a demand can only be made by special permission of the trial court. The burden is on the accused to protect his statutory rights to a speedy trial by making a timely demand at trial under the code provision. The statute affords no exception to these directives. And it gave us case cleaned up, emphasis applied. Then it gave a case number C, also Bonakis versus State. Charge and acquittal based on statutory speedy trial demands an extreme sanction that requires strict statutory compliance, emphasis applied. Notably, Farley's statutory speedy trial demand is not in a strict compliance with the statute for reason in addition to the fact that it is fatally untimely. First, it was not filed as a separate, distinct, and individual document that is not part of any pleading or document. Exhibit B. Second, it makes no reference to OCGA 17-7-171, the appropriate code section for defendant accused of a capital offense. 11, even assuming argumento that Farley's November 29, 2022 statutory speedy trial demand is somehow valid, it would nevertheless be moot to the extent that his trial started on January 4th, 2023. No, didn't the trial start on January 9th, y'all? Not the 4th? For these reasons, the statute respectfully requests that this honorable court dismisses Farley's November 29, 2022 demand for a speedy trial as untimely, invalid, and no force and effect, respectively submitted the 11th day of April, 2023. Fannie T. Willis, Adrienne Love. Okay, there it is. And this is the this is when the judge put a halt on the What's the eggplant for, James? What's the eggplant for? What are you saying? Okay, this is a judge putting in. This is he's being disrespectful. Block him, Sharon. Block him because he want to come in here and play, be disrespectful games. Block him. All right, now we're gonna do the next one. We're gonna do Mr. Ryan, his attorney. Remember the young man? Remember Rod's dad? You know, his dad was on my live for interview. You know what? Let me call him for a second. Hold on, y'all. Let me make a phone call to Mr. Rod dad and tell him, hey, I haven't talked to him in a while, y'all. Let's make a call to him. Hold on, I'm making a call to him. Hold on, y'all. Let's see if he's around for me to talk to him. Thank you, Rand. Hello. Hi.
Hey, how you been doing?
I'm good. I'm on live, but I'm getting ready to read the motion of your son's counsel requesting to withdraw from the case.
She's asking to withdraw from the case.
She's asking to withdraw from the case.
Why is she asking to withdraw from the case?
Well, come on in and listen to it. I'm bringing it up. I'm gonna read it right now.
How long is it gonna be?
I'm doing it right now.
Oh, shit. Okay, let me get to the computer. I'll call you right back.
Okay.
Give me the link.
Send you the link? You want to come up? Okay, let me send you the link then. Okay. All right, bye.
I'm gonna want to give you some link.
I'll send you the link. Okay.
Okay.
Y'all, the dad wants to come on. Hold on, y'all. His dad wants to come on. He didn't even know the attorney's asking to withdraw. Wow. And this is funny. This is weird. Hold on, y'all. Hold on. You know Sylvie be on it, y'all. Hold on, let me get the link for him. Hold on, get the link. Hold on, y'all. Invite. Copy. I gotta send it to him. All right, I just sent him the link. She put this in yesterday to withdraw. Y'all, we're about to hear something. This is gonna be crazy, y'all. All right, guys, while we're waiting on him to hit the link, let's ooh. What do you mean what happened with Getty? What do you mean what happened with Getty? Hello? Hi. Oh, you wasn't in the office? Okay. Okay. Okay, good. Mm-hmm. Mm-hmm. Okay. Okay. Thank you. Thank you. It's okay. I understand. I did not know. See, that's why I sent an email out. Thank you. Thank you. Okay. All right. Thank you. All right. Okay. Okay. And what time is court? Okay, because I didn't get an email on that. Okay, all right. Okay. Okay, all right. Okay, thank you. Bye-bye. Hey,
Hey,
how are you?
I'm doing great. Yourself?
I'm doing wonderful. I'm doing wonderful. So we're gonna go ahead on and read why she wants to be withdrawn from the case. So I guess you didn't know that.
No, I haven't. Actually, I haven't been like in town. I've been like down in Newman trying to do some more things.
Yeah, I understand.
But I
So,
spoke to him yesterday. He never spoke to me. I spoke to him yesterday.
oh wow. So what I'm gonna do, I'm gonna put it up so we can read it all together. All right, here it is right here. You see it? Can you see that? Or should I make it
No,
bigger?
still up. Okay.
And then I can't read the side if I make it that little. Hold on a second. Let me make it bigger.
Okay, I got it.
Hold on a second. Let me get the other side. All right, I can read it now. You ready?
Yes, ma'am.
All right. You might need to mute your phone because they can't hear you. Let me mute you. Because there's a lot of noise in the background. Let me go ahead and read this for you. All right, you ready? It says, State of Georgia versus Rogers Ryan Jr. And it says here, motion to withdraw as counsel. Now comes Angela D. Williams, attorney on record for Rogers Ryan Jr. in this matter and respectfully request leave to withdraw from the provision of Rule 4.3 of the Uniform Superior Court Rule of Georgia. The undersigned has given her client due written notice of this intention to withdraw prior to submitting this request to the court, as shown by the attached notification certificate. Counsel is appointed to this case, and the Georgia Public Defender Counsel or Fulton County refused to pay a fair wage. I have a meaningful discussion with counsel in regards to payment, as stated in the attached letter. The trial for this case began January 9th, 2023, and once opening statement begins, trial is slated to last at least 6 months. The amount that the public defender has paid is an grievously low amount for the amount of work and attention to this trial requires. In accordance with therewith, the undersigned certifies that Rogers Ryan Jr. is further informed under the above rule. A, the Fulton County Superior Court retains jurisdiction of this matter. B, defendant has the burden of keeping the court informed of his current address for the services of notice, pleading, and other paperwork. Of other papers. C, defendant has obligation to prepare to go forward with this case with appointed counsel. D, if defendant fails to or refuse to meet these obligations, he may suffer adverse consequences, including the entry of judgment against them. E, defendant must file an objection within 10 days from the date of this filing or come to this motion hearing to have his objection heard regarding this motion. Wherefore, the undersigned Angela D. Williams respectfully requests that an order be entered permitting her to withdraw as attorney of record for Rogers Ryan Jr. Attorney K.R. Colby joins on this motion to withdraw. Okay, you heard this? It's because of money. They're not paying her enough. Hold on, let me unmute you. Hold on, let me unmute you. Hold on. Okay.
We had no problem with that. but he having the attorney that he's using on this case, he didn't need an attorney. Because he don't even know these people. Why spend $40,000-$50,000 on an attorney? He never needed an attorney for that charge. He don't even know these people. Now, on his retrial for his murder charge, he will have an attorney.
Okay. So
Northern Wright's gonna represent him on his retrial for his previous case. My son, I don't even know why he's there. He don't even know anything about this case.
This is like really like weird, isn't it?
It's crazy. I spoke to her last Thursday. I took some clothes down there. She never spoke to me about this.
Well, she said she contacted your son and told him that she's withdrawing. That's what the paperwork just said.
Okay. Can you give me about 20 minutes? Let me contact her, because I mean her service was never needed. Because he don't even know anything about the case. They don't.
Yeah. This is crazy.
That's one reason. The case.
Your phone is messing up. We can't hear you.
Okay, hold on. Let me get right with you, because I'm getting in the tow truck right now. I'm headed back to the city.
Okay. All right. Well, guys, y'all heard it. He didn't even know. He didn't even know, guys. This is some weird stuff going on here. This is some weird stuff. Hold on, I had to put my little thing on because folks are trying to steal my stuff, so I had to put a little marker when he started talking. Well. Well, isn't that different? This case gets weirder and weirder and weirder by a moment. Weird and weird by the moment. Yeah, Felicia, I'm glad I called him too. All right, we're going on to the next motion. That was that one. We can handle that situation. All right, we're going to Mr. Stillwell. They oppose Mr. Stillwell's motion as well. Let's go ahead on and show this motion. Hold on. Exactly. What the heck? Okay. All right. I know we're supposed to be going live with Mr. Kelly's update, but one of the two young ladies has class, and let me just see if Siobhan will still be coming up on there. And we're going to end this live and see if they are ready to come on. Hold on. Let me see. Let me see if she'll be ready in a few minutes. Let's see. Before we move on to our next thing. Hold on a second. I just talked to her. I have her wrong number. Let me see. Hold on. Where's the number that I called her on? Hold on. Hold on. There you go. There go the number. She may not be available. Okay, we're gonna have to push it out because she's not available. She's not answering. So let's continue. Can someone bring me up to speed? I just got in. Top Guy 305. There's a lot to bring you up to speed. It's a lot that we just did. I showed different motions. We've been on for an hour and something. It's a lot. Hold on. Hey, lady. Oh, okay. Oh, okay. Shantae said that she's not going to be available until after class. The class get out 9:30, and you're ready. So do you want to go ahead and do? Okay, y'all. I'm gonna end this live, and we can continue this later on tomorrow, maybe tomorrow, and we could do this tomorrow. His dad is gonna call me back anyway. All right, so we're gonna pause this, and tomorrow remind me that we're on Stillwell, because since court is like, I'm not gonna go waste gas going down there. They only have 3 people to do tomorrow. They only have 3 hardship to do tomorrow. I'm not gonna waste my gas to go down there, so we can just do these the things that that I haven't gotten to, because I have a lot of motions that I'm going to go ahead and talk about. Sounds good, guys? How does that sound? Y'all okay with that? Sounds good? Oh, you like my shirt? It's thank you. You know that company that, I was watching the Super Bowl, right? I was watching the Super Bowl. Remember that company that came up with Temu, Temu? They was doing a whole bunch of commercials, and I said, okay, let me go in there. And then when I saw the stuff, they had so much cheap stuff in there. I was like, oh, this came from Temu, y'all. Temu. And I think I paid like what? $5 or something like that. $5 for this shirt. But they had like all these little gadget, Temu. And they came on the Super Bowl. That was their first time coming on. They were just, in fact, they're giving me, I think, $50 spending thing, because they want me to talk about them on my YouTube. So, Temu. And they didn't give me a link or anything. So I need to get a link so they can give me some money. So if I talk about them, they say they want me to. See, here it is. And look, they gave me a little, look, I'm going to show y'all something. Hold on. Speaking of them, they just sent me an email. Let me show you what the little email they just sent me. They said they got a little gift for me or something like that. Hold on. Oh, yeah, look, see, it just said gift box. And they gave me my code. Look. You still have unopened surprise box. So they got me a box for me to advertise them. And look, you talked about it. You talked about it, Galatian Vogue. Good, there it is. I was scrolling through it, Facebook and stuff a few weeks ago. I'm gonna check it out. So they have. And so I end up, me, gadget girl, and this is where this shirt came from. This shirt came from there. This is my first time wearing it. It's an old person shirt, but it was cheap, so why not? It's not bad. It's just an old person. Look really old, like an old lady's top. And I got a whole bunch of pajamas from them too. A whole bunch of pajamas. You know those pajamas that you see me wearing with the little set? That came from them. Yeah, I went and bought a whole bunch of stuff. And they were like inexpensive. So that's where this stuff came from. But anyway, guys, I will check you guys later. I'll be back on at 6:45 with Siobhan, and we're gonna have a discussion in regards to the text messages and all that good stuff, because she has some insight, because she was at the courthouse. I was at the courthouse. We're gonna do it with Shantae, but Shantae's at school and stuff like that. So we're gonna work with who we have. Okay. Oh, I'm sorry, because it's like an old person pattern. It's like old folks pattern. Like, come on, man, look at this shirt. Like an old folks pattern. Look at it. Oh, sorry, I'm all up in the camera. It's like the old folks pattern. All right, guys. I'll check you guys later. Shout out to Mr. Rodley Mr. Rod for gracing us on this channel. I think I kind of opened up a can of worms. I didn't even know. I was just, going to ask him questions about the whole attorney quitting, and she's quitting because no money. She's not getting enough money. I knew this was going to happen eventually. I wonder if they're giving them $25 a day like they're giving the jurors. What do you think? Can they give an attorney $25 a day? I would love to hear from her how much money she's getting a day. I like to hear. It matches my lipstick. The color. Sharon said everything happens for a reason. Y'all, guess what? See, you guys been praying for me. Y'all guys been praying for me. Guess who called me? DFAX called me, right? They told me the foster mother of Fahim, because Fahim's temporarily with a foster mother. She wants to stay in contact with me, so make sure I keep in contact with the baby, with Fahim, y'all. See how God's working it out? See how God's working it out? You see? Woo. Working it out. Because tomorrow's court. She said, working it out. She said the foster mom wants to keep in contact. Because, I emailed them, y'all. You see, we ain't playing. We ain't playing over here, y'all. I got a army behind me. We ain't playing, are we, guys? We ain't playing. Fahim is the YouTube baby. We ain't playing with these people, are we, guys? We're not playing. You see what happened? She told me she was off. That's why her voicemail things was going to her voicemail. She's off, but she happened to see my voicemail, and because I emailed them. Not only did I do a voicemail, I emailed them, y'all. I emailed them, and so she says the foster mom wants to keep in contact with me. And I'm gonna go see Fahim. They're only making $50,000. What, Tanya? Yeah, nice water. It was in paperwork? Oh, hold on. Tanya, I wasn't paying attention. Let me see. Okay, the paperwork said there was, hold on, let me go back to the paperwork. Let me go see the paperwork. Hold on. Did she say 50,000? She didn't say the amount of money. She didn't say the amount of money. She just said it's low. Or the exhibit A. Oh, we didn't go down and look at the exhibit yet. Hold on. We didn't look at the exhibit. Hold on. Let me go put it up. Hold on. I didn't even go all the way down. Thank you. Toya. Toya, thank you. Hold on, y'all. We got to go back and put it up. Hold on. We got to go back and put it up. Okay, here we go. Look. Okay. Oh, let's read. Oh, my God. I apologize. Let me go look at it. Okay. It says defender. It says attorney contract agreement, YSL trial. It has attorney for Roger and Justin for Blaylock. Blaylock attorneys leaving too? Jimenez, attorney for, okay. And in this correspondence, find you well, GPDC receive your request for additional compensation per month for representing the respective YSL trial involved indigent clients via your contract with GPDC. GPDC is unable to provide additional compensation beyond the contractual case payment and the one-time separate supplement of blank. I must underscore the distinction between GPDC and the separate Fulton County C3 program. The Fulton County C3 program is a county-run and county-funded initiative entirely separate from GPDC. The flyer reference is your past communication advertising $140 is from the Fulton C3 program. CPDC does not pay hourly rate. Of note, the Fulton C program cap payment is at $20,000 per case and require attorneys to handle their client's appeal. Oh my God, 20,000? No, it's less than the amount that you put down, Toya. 20,000 per case? How the heck they think the attorney's supposed to survive with $20,000 per case? As you are no doubt aware, you signed contract to represent your respective client with GPDC, not the Fulton C program. And what the Fulton C program does and does not pay attorney contract with it has no bearings on your extract contract with CPDC. We appreciate your unique circumstances of the YSL trial. We have already provided an additional supplement beyond your contractual payment. Please know GPDC is engaging Fulton County to explore the possibility of Fulton providing other compensation. There is ongoing and will notify you for the notable progress. In the meantime, it is not necessary that we meet. Thank you for attention and correspondence. Oh, child, y'all. Oh, my God. Lord have mercy. $20,000? Oh, my God. $20,000 and the case has not even started? $20,000 for this case? And they're going to be on this case a whole year? Oh my God. $20,000? What? Oh, we definitely gonna have to do a live on that. $20,000. The attorneys are making less than people that work at McDonald's. Let's break this down. Let's see how much this is gonna be. Because it's gonna be a year for this daggone trial. Let's break this down. Let's break this down, y'all. Let's break this down. Let's break this down. What? Hold on. 20 divided by what? Hold on, y'all. Hold on. 20,000 divided by, what is it, about 40, 50 weeks, right? How many weeks? Hey, Danny. How many weeks? Okay, from January 9th, that's like the beginning of the year, right? Okay, let's say 51 weeks. Let's do 51 weeks. That's $392 a week. That's if we do 51. That's $392 a week. $392 a week. Oh, God. They don't want the attorneys to go to the poorhouse. Wow. $352 a week, y'all. A lot of y'all making way more than the attorneys. And they went to law school, pay all that lawyer money. Oh my God. What? What? Oh my goodness. No wonder why I kept seeing a lot of attorneys quitting. I think there was another attorney I saw that's quitting. Hold on. Oh my God. That is so crazy. $20,000 per case. And this case hasn't even started. Oh, no wonder I didn't see any motions filed by them. Y'all, this case. Oh my Lord. And they have to be there every day. Do you know how much money is they spending paying for parking every day? $20 per day for parking, y'all. $25 times 5 days a week for parking. So out of that $392 they're getting for that week, parking alone times 5, $100 for parking. So he's really getting $292. This is crazy. This is nuts. Wow. 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 She's a public defender. Yes, she is, Shalani. Wow. Oh my God. $20,000 a case? That's if it was like a case that's like 2-week case or a month case. But a case that's lasting a whole year? You want to give me $20,000? You don't bump your head. And I can't leave. I can't do nothing. I can't even sneak to the store. You done bump your head. Oh no, y'all done bumped your head. Y'all think I'm gonna get $20,000 for a case? You done bumped your head. You done bumped your head. That's poverty wage. guys. Did y'all hear that? Okay, let me put this document back up and show you guys how much they're getting paid. Hold on, we're gonna put this back up. We're gonna show this. This is shameful. This is so much shame here. Hold on. Oh my God. That is crazy, y'all. That is crazy. You see this? Hold on. We're going to go all the way down. Look at the amount they're getting. Caps payment at $20,000 per case. And it's to handle the case and the appeal process. The case and the appeal process. Y'all see that? The case and the appeal process. This is crazy. Oh, okay. All right. On that note, I'm about to get off this live because this in itself is a tragedy. This in itself is a tragedy. $20,000 and you expect them to stay the whole year. And then you see they can't even get jurors. Jurors only getting $25 a day. How much is that? The jurors getting paid more than the lawyer? Hold on a second. 25 times. No, they're getting $125 for the week. Okay. So the lawyer's getting a little bit more than the jurors. So jurors, they really not gonna get anything because if they get, oh no, they get a parking downtown somewhere. Okay. Gotta go, y'all. We gotta go. We have exposed a little bit too much today. We exposed too much today. Lord have mercy, Jesus. Father, help them. Do you know what? They're trying to put the poor attorneys in the poorhouse. Oh my Lord, my Lord, my Lord, my Lord, my Lord. Wow. Okay, we gotta go. I'll see you guys later. This was just shocking just now. You said, Toya, you said you thought it was $50,000. It's $20,000. 20, not 50. There's no way. There's no way in heck. There's no way. You might as well say you did it on pro bono. You might as well say this case is pro bono. Because $20,000 ain't going to do nothing to nobody's household. Not attorneys. Oh, gotta go. Gotta go, y'all. Gotta go. Y'all just spoil my day right there. Y'all spoil my mindset. Okay, gotta go, y'all. We're going to come back with Mr. Kelly. Do an update on Mr. Kelly. Okay, later. Bye, y'all.